I'm Drew Stevenson, and this is a lecture about the case United States versus Nova Scotia Food Products Corporation. This is a case from the Second Circuit Court of Appeals in 1977 that's really a famous case in the area of administrative or regulatory law. And this is really about how courts should construe the procedural requirements in the specific procedural requirements in Section 553 of the Administrative Procedure Act. Now, for my students, I want to mention this case is actually I cover this in two of my courses, Administrative Law and Statutory Interpretation and Regulation, or Leg-Reg. It's in both of the case books. It's probably in most administrative law case books. Even though it's not a Supreme Court case, this case really kind of set some of the parameters that courts since then have followed in what's really required of an agency during notice and comment rulemaking. And in particular, some of the stuff that agencies need to include in a proposed rule when they publish it in the Federal Register, or in the final rule when they publish it in the Federal Register. So let's look at what happened in the case itself. I'm going to start with a main takeaway in case you you give up on me as we go along. Basically, the Food and Drug Administration brought an enforcement action against a processor of smoked whitefish for violating safety regs. So this is sold in jars in supermarkets, and these whitefish, it's usually comes in a brine. And sometimes they're sold in my local supermarkets. They're in the kosher food section usually. And the Second Circuit had kind of a few different parts of its holding here. First, they said that the FDA didn't really comply with the APA's rulemaking procedures because they didn't disclose during the notice and comment period the scientific data that they were using to determine safety standards for the commercial cooking of whitefish. In other words, they had to settle on cooking temperatures and salt content for the brine and so forth in order to protect against disease or contamination of the fish. And they had done scientific studies and collected studies that were the basis of this, but they didn't tell anybody what those studies were. And that was the problem here. They also held, the Second Circuit also holds here, that this statement of basis and purpose that the FDA put in when they published the rule left too many unanswered questions. They didn't really address why they had decided on a single rule for all types of whitefish instead of specific rules for different varieties of fish and so forth, like the industry wanted. And also the industry had said that the cooking temperatures that the FDA was requiring would overcook the fish and make it rubbery and inedible for consumers. And the FDA had kind of ignored this during the, both in the proposed rule and in the final rule, or at least in terms of what they published. So let's start with our statute. When the statute here that's relevant is the Food, Drug, and Cosmetics Act, or FDCA, which makes it unlawful to sell, quote, adulterated food. And what does adulterated mean? Well, there's a definition section in the statute. It defines it as food that has been prepared, packed, or held under insanitary conditions whereby it may have become contaminated with filth, or whereby it may have been rendered injurious to health. And so with the case of meat products or fish or chicken or anything like that, for example, if you leave it sitting out for too long or don't refrigerate it enough or don't cook it thoroughly, you can get bacteria growing in it. And that actually was the concern with the whitefish. In the 1960s, the people were dying. There were poisoning incidents from botulism. That's a disease, a very serious disease from bacteria in food, and it was from this kind of fish, from smoked and or salted whitefish, and it was sold in supermarkets. So there was a public outcry and a lot of national media attention, pressure from politicians, and the FDA itself was concerned. So they decided to make a rule about the conditions for cooking and processing it to make sure that they were keeping the consumer safe. And they did this through notice and comment or informal rulemaking pursuant to Section 553 of the Administrative Procedure Act. So the FDA published a proposed rule in the Federal Register like they're supposed to. And that rule would have required smoked or salted fish to be cooked at 180 degrees for 30 minutes. Well, the industry didn't like that. And by the way, this is a picture that I have here of the jars that are available in my supermarket of the leading brand of canned whitefish, but it's not necessarily the same brand at issue in this case. The agency received a lot of comments from the regulated industry. The regulated industry was very unhappy. And so during the notice and comment period, a lot of whitefish producers, including Nova Scotia, had submitted comments criticizing the proposed rule. And the FDA collected these comments, and they actually changed the final rule was a little bit different. They adopted some modest changes. And what they did was they said, well, we still want 180 degrees, or you can increase the salt level or salinity of the brine, and then you only have to cook it at 150 degrees instead. So they basically tried to compromise with the industry and allow this alternative process. Well, what the industry had really asked for was that that the FDA promulgate a completely distinct rule or specific rule for time, temperature, and salinity for every species of fish, and with the argument that every species of fish has a different consistency when you cook it at different temperatures. And by the way, personally, I think that this was disingenuous on the part of the industry. I think they were trying to create indefinite delays with the FDA, right? And so instead of the FDA getting to promulgate one rule, they would have to promulgate dozens and dozens of rules. This would take from now until kingdom come. And so the industry's kind of buying themselves an indefinite amount of time here. The FDA also kind of ignored some objections, or at least they didn't acknowledge them when they published their final rule about what was going to happen, that certain types of fish would be too overcooked and be too rubbery to eat, and therefore basically wouldn't sell, would be unmarketable on the consumer market. But by the way, the story goes that this fell apart at trial. They had one of the Nova Scotia executives take the stand and do a blind taste test of fish cooked at different temperatures, and he actually couldn't tell the difference. But remember, we're not talking about what happened at trial here. We're actually talking about what happened way before that, when the FDA was doing their notice and comment rulemaking period. That's what's really at issue in this appeal. So after the rule went into effect, the FDA brought an enforcement action against the Nova Scotia Food Products Company because they weren't cooking their whitefish, like shown in this picture, at the temperatures and for the length of time specified. And what Nova Scotia did was they said, well, as their defense was that the rule was invalid because the the FDA didn't follow APA procedural rules. And for my students, this is one of the little lessons from this case, if you're going to kind of peek under the hood of administrative law, that a lot of times our court decisions about administrative law are issues that are raised in the context of an enforcement action where we're challenging the legality of a rule itself as the defense. So Nova Scotia, instead of denying their violation, is saying we violated an illegitimate rule. They also argued, by the way, that the FDA didn't even have statutory authority to promulgate a rule like this, or tell companies what temperature they have to cook their food at the factory. And the court rejected that claim. And by the way, there's also a story from this case that the FDA, when the case was over, even though they had lost this, they had to do this regulation over again. They thought it was the big win was that it settled it that they have statutory authority under their enabling statute. Apparently, they weren't even sure themselves to regulate food production in food factories. So, but more important for our purposes, like why is this case in your casebook, are the procedural deficiencies of the FDA's rulemaking activity. And there's two main ones alleged here. First, the agency didn't disclose some factual material, its scientific studies on which it relied to make determinations about cooking temperatures and salinity and safety. So they had to pick a number for what's our TTS level, our what temperature do they have to cook the food at, and they settled on a number, drew the line based on certain research that they had done. And that's all fine, but they didn't tell the industry that when they did the notice during the notice and comment period, which kind of deprived the regulated industry of the opportunity to look at the study, have their own scientists look at those studies and see if there were methodological problems, or maybe the agency was misreading the findings or something like that. And there was no real opportunity to scrutinize the scientific research that the agency was relying on. And secondly, Nova Scotia said that the FDA put out a statement of basis and purpose that was inadequate because they didn't really address the commercial feasibility of rubbery fish or overcooked fish. And so now at this point, I want to draw your attention to the APA, which you may want to take a look at in reference to this case. In 553, it requires agencies to include a concise general statement of the basis and purpose of a regulation when they propose it and in the final rule. And well, that doesn't say much, and it doesn't really sound like much. And so what we really get here is a judicial gloss on the APA saying concise general statement should include whatever your scientific research was that led you to settle on the specific rules or line drawing that you did. And after Nova Scotia and some similar cases in the 1970s, these concise general statements became anything but. They're now quite lengthy and detailed if you read proposed rules in the Federal Register. So this requirement that the agency has to disclose its scientific studies is really hard to find in the plain meaning or the text of the APA itself. So if you consider yourself a strict textualist and you're going to look at the Administrative Procedure Act, you're going to have trouble finding this type of requirement in 553B. And if anything, you could have concluded the opposite. You might say, because 553B does require the agency to be specific about its legal authority, like cite your enabling statute, and that the fact that they only mention legal authority under some canons of construction might be taken as a negative inference that there isn't really a parallel obligation to disclose the factual basis for a proposed rule. Furthermore, the 5535B of the APA requires agencies merely to disclose, quote, either the terms or substance of the proposed rule or a description of the subjects and issues involved. Now, I know for some of you, this is really getting boring, and this whole case is about something gross, dead fish, right? But bear with me for a moment. This is one of the only cases we do that really drills down on the nitty-gritty of Section 553. And that phrase that I have on the screen here doesn't really sound like a requirement that the agency publish all of its scientific studies and research and factual basis for a proposed rule. But the court here is sort of reading between the lines and saying that's what you have to do. Where this leaves us is courts, some courts would conclude that if the agency doesn't release its scientific studies, that there's no meaningful opportunity for comment by the regulated industry. Or they might say that it's arbitrary and capricious under APA 706 if we don't disclose its studies. And this issue comes up later as we move into the late 70s and 1980s and 90s, where courts basically required the agency to really pad the file, the record of their decision making. So even if it wasn't published, that when we get to judicial review, the courts want to see how the agency came up with the rule that they did. And so some courts under similar cases to this would have said that agencies have an obligation to consider all relevant factors, including potential objections to the studies. And therefore, if they don't disclose the studies, then it's going to make their final rule arbitrary and capricious. Okay, where does this leave us, this Nova Scotia case? Keep in mind that there's trade-offs when we require agencies to provide detailed explanations of every rule and every study reviewed and every rejected counterproposal, right? So that's going to slow agencies down. If you are reform-minded and really want the regulatory agencies to fix more things and address outstanding social problems, or even fix broken rules that aren't working well, now this is a lot of layers of burdens on the agency. On the other hand, requiring a lot of these explanatory statements does promote transparency in government and deliberation and meaningful judicial and political oversight of agency decision making. In other words, transparency is sort of a good thing, especially when we're talking about unelected bureaucrats, that maybe we want to make them kind of tell us what they're doing and why. On the other hand, remember that requiring detailed explanations and responses can create a perverse incentive for regulated parties or activists to file a barrage of objections and counterproposals during the public comment period in hopes that the agency will fail to address some point, and that will give a hook for legal challenges later. In other words, if you're worried that you're going to be the target of an enforcement action, you should file a whole bunch of complaints and criticisms during the comment period in hopes that one of them will sort of slip through or fall through the cracks, and that will be your defense if you are targeted in an enforcement action later on. And so there can be some perverse incentives created here. Okay, here's a review question to see if you're still with me and paying attention. During notice and comment rulemaking, if the regulated industry submits comments proposing an alternate rule that might be better, does the agency have to address this when it publishes its final rule? Yes or no? Hopefully you kind of got the answer to that. And if you're not really sure, maybe you should review this video. And that concludes our lecture about the Nova Scotia food products case.